Now call the second case on this morning's docket. That is case number 114944, State of Kansas v. Larry Toothman.
May it please the court, counsel. Get Corey Call representing Mr. Toothman. Request 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you. Mr. Toothman was charged with committing numerous sex crimes against his niece and was convicted of, I think most of those would be fair, and acquitted of some. There was very little, I don't think there was any physical evidence. It was the testimony of the niece against Mr. Toothman. We raised 3 issues in the brief. The first was that the state had charged several counts of aggravated criminal sodomy, and then charged in the alternative criminal sodomy. I think the question was whether there was consensual difference between the two. And it's rather than charging criminal sodomy as a lesser. The second issue, there's a nullification again. And the third issue at sentencing, Mr. Toothman had mentioned that he wanted his attorney withdrawn because he had given her several letters. He wanted several letters that the jail had subpoenaed. He's coming to his trial because he thought that would have helped his case. Again, I'll talk about whatever the court wants to talk about, but we'll just maybe start at the top and go down. The Court of Appeals, in this case, found that it was error to give the to charge these and instruct these in the alternative as opposed to as lessers, but they found it was harmless. The state did not appeal, finding that it was error, so we're really here on whether it was harmless, on the harmless error. And I'll start off embarrassingly. I will say the Court of Appeals pointed out that there were 3 relevant convictions on aggravated. The state charged in the alternative 3 counts of aggravated criminal sodomy and in the alternative criminal sodomy. And for some reason, I had only mentioned 2 of those, so I guess we're only talking about 2 of those. I think the issue applies across the board. But so we'll do counts 1 and 2. And as I understand the analysis from the Court of Appeals, it's really that they found him guilty of both. In these cases, they acquitted on one of the aggravated crim sodomy pair, but convicted of aggravated sodomy and sodomy, both. They returned verdict on both, as they do, as they're supposed to do when it's in the alternative. And because they've been convicted of aggravated criminal sodomy, it's basically harmless that it wasn't as a lesser, because the way the instructions are, they never would have gotten to the criminal sodomy, because if you convict on the first, then there's no need to reach the second one. You only move to the lesser if it's you find there's reasonable doubt as to the top charge. But that's always sort of the problem with lesser includeds, is when I think this is somewhat akin to the failure to instruct on a lesser, in the same sort of analysis, the idea that they found him guilty of the top charge, so they wouldn't need to reach the lesser. But that's not the analysis we do. We look to whether there was overwhelming evidence of the greater and whether or not that is the harmless error. And here, there were questions about I believe the verdicts indicate that the jury had questions about the credibility of the victim, that they acquitted of several charges. And there was, I don't believe there was any physical evidence. There was no DNA, no confessions.
Isn't the problem with not giving a lesser that the jury, it's an all or nothing deal? The jury doesn't have that, I'll call it the middle road or the middle option. Isn't that the primary problem with failing to give a lesser?
I think it's a problem.
But that's not a problem in this case. Even though there may be error in the technical way that it was presented to the jury did still have that option to acquit on the greater and convict on the lesser.
Except, correct.
They just didn't get the instruction.
Right, but the instruction also says that if you have a reasonable doubt as to which one you're going to pick, then you can only convict of the lesser. And they weren't given that instruction as well. And so it specifically talks about the reasonable doubt as to which charge. And so that is a key part of the instruction that wasn't given.
How would they have had a reasonable doubt about the greater if they convicted on the greater?
Well, I believe the instruction says as to which charge. I think if you find both, then you have a reasonable doubt as to which, then you can only convict of the lesser. I believe that's the way that instruction is worded. So given the two here, they didn't have to choose. I think when there's a greater and a lesser, a juror can see, okay, we have both, but we have a reasonable doubt as to which one it is. You have to go with the lesser. And so here they didn't have to consider the two in conjunction. They could just convict of both. And given that, then I think that's the critical distinction.
I guess if you find that you're guilty of the greater offense, it necessarily means you're guilty of the lesser included, doesn't it?
In criminal sodomy, it would be.
Right.
Yes, that's right.
Okay.
There's also race nullification issue, which we talked quite a bit about, and I don't know that I have anything further to the court in this case. The court in this case seemed to draw a distinction between the idea that whether the verdict must be founded on the evidence of the law, as whether the jury must consider the evidence in the law. And I think there's a pretty big difference between telling a jury the verdict must be founded on the evidence and telling them that they had to consider the law and the evidence. I think that's a pretty big distinction. And finally, we had on the sentencing issue, Mr. Toothman told his attorney about some letters. She had said she didn't know about the letters, but that she had gotten some letters from him. The judge made some inquiry as far as saying, what about Mr. Do you know about these letters? Yes, he told me, or no, I hadn't read the letters, and that. But there was no further inquiry to determine how much of a conflict was Mr. Toothman was asking that should be removed because they had this conflict. And there was no inquiry as to, well, what kind of communication, how does this affect your relationship? Those kind of questions which are critical to determining whether or not attorneys should be removed for sentencing. And what we're asking for here is an inquiry, because we don't have enough information to remand for an actual resentencing, I don't think, but we need an inquiry into the extent of the relationship. I guess the Court of Appeals, sua sponte, raised a Carmichael issue. Carmichael was the case that talked about, that said that aggravated incest was identical to, I think it was rape, but anyway, the sex crimes. So they said they reversed those in order to be sentenced on for aggravated incest. I think the critical part of that opinion is where the Court of Appeals says that the law has not changed since Carmichael, and I think this court needs to look at that. And if that's right, if there haven't been substantial changes that affect the decision of Carmichael, then Carmichael will control, and Mr. Toothman is due Carmichael relief. I think there were probably some changes in there.
All the elements of aggravated incest were not included in aggravated sodomy and rape, right?
That's because the family member aggravated incest requires family.
What I'm saying is there were elements here of aggravated incest that was not decided by the jury.
I don't remember if they if they were charging the alternative, the jury may have checked that box. I'll have to double check, but I know that they were charged in the alternative on some, and so that may be a question. But you certainly may be correct. That if they were not charged in the alternative, then yes, there would be elements that were not found by a jury.
I mean, I can understand reversing, but I don't understand the Court of Appeals then convicting of a crime that the jury didn't find all the elements of.
Right. Yeah, I understand. I certainly, yes. I think that would be correct.
Any further presentation?
Okay.
We have any more questions? Thank you, counsel.
Thank you.
May it please the court, Annie Infinite for Saline County. My petition review was also granted so the state would request 4 minutes of rebuttal, if that's allowed.
That's a new one on me.
Both were granted on separate issues. Mine was granted on the issue of the sua sponte raised by the Court of Appeals, and then the Carmichael issue, as counsel called it. If that's not allowed, that's fine. I was just told to give it a shot.
Ask for, give it a shot.
Give it a shot.
Well, Rule 701E says the appellant may reserve a portion of that time for rebuttal by making an oral request at the time of hearing. So, are you considering yourself the appellant?
We're at appellee, so that, and not always that's fine. I'll withdraw that request. As far as your judge, you had asked if there was an alternate count for aggravated incest, counts 3 and 11. They did actually have the aggravated incest as alternative counts for the jury to consider. Count 3 had aggravated criminal sodomy and aggravated incest. Count 11 was rape and aggravated incest. The state's issue with how the Court of Appeals handled this is there was significant changes after Carmichael. There was initial Williams, Chandler, and Carmichael, where they had a series of cases essentially setting aside the more serious sex crimes where it was deemed their rape and criminal sodomy were general crimes, and imposing what they deemed the more specific crime as aggravated incest. However, after Carmichael, there was legislative change going through starting in 1996, as that was outlined very detailed in Ippert, which was in 2000, and then reiterated in Sims in 2005. Through there, essentially they said there's no reason that a defendant should have some sort of lesser sentence or lesser punishment, if you will, simply because they had a sex act against a family member. Essentially, they said if there's an otherwise lawful sex act, then it would be proper to go through an aggravated incest. However, with the way state charged it here, we have the alternative count, again, ag crim sodomy and count 3, rape and count 11. Those have the component of force or fear, essentially a non-consensual act. And as it's very clearly stated in Sims, that makes that an unlawful sex act, which makes it something that is not for consideration for aggravated incest. That was all before the jury, and the jury had to make that determination of whether or not they deemed these to be consensual sex acts. With their conviction of Mr. Toothman of the more serious crimes, state's contention on that is that they did make that decision that this was a non-consensual act and it was appropriate to impose the more serious crime.
What did they do with the alternative count?
They convicted on both, and that's what they did on every, there was 11 accounts. I believe he was convicted on 6 of those, maybe it was just 5, but each one of those that he was convicted on, he was convicted of the primary offense and the alternative.
That was clear from the verdict.
Yes.
Okay, thanks.
But under your view of the statutes, those crimes are mutually exclusive.
The varying component would be whether or not they were consensual. If they're not consensual, then they're not deemed a lawful sex act, and therefore that makes it allowable for the state to proceed on the more serious
Sure, but
charge.
it's not factually possible to be guilty of both crimes under your view of how the statutes read.
Correct. And that was what was before the jury, is to make that determination.
But they picked both. And I guess, is that even a question on appeal? That was the one sort of hiccup I had with when
Well,
looking at this. What do we do with that?
It was not on appeal, and part of that would be because of the way the Court of Appeals handled the matter. They first of all set forth what their standard is if they raised that issue sua sponte. It was never briefed. They went through and took the time, says, if an issue is raised sua sponte, it's supposed to go back for briefing, and then they proceeded to make a
This
decision.
case might be a poster child for why there ought to be additional briefing, maybe.
Well, that is very true, because they acknowledge that that's the way that the procedure is supposed to go, and then they proceeded to not follow that procedure that this court set forth for it to do. So from the, like I said, from the state's perspective, the Court of Appeals essentially just set aside whatever the determination that was made by the jury. They reweighed the evidence, they made that determination, they took away the more serious charge that the jury had found. And we're just asking for those charges of the aggravated criminal sodomy in count 3 and rape in count 11 to be reinstated as was found by the jury.
I'm just struggling with how we deal with inconsistent verdicts when we have kind of the harmlessness analysis that the Court of Appeals has used on other counts, and now you're asking us basically, I think, to do that here and say, oh, always go to the more severe crime. But if incest is inconsistent with the ag sodomy, why do we go with the more severe?
In this particular issue, it was still before the jury whether or not it was a consensual act. Why they made that determination on both counts, I can't answer you that, but case law is very clear that the two charges would merge and that the more serious charge would then be put before the defendant. And frankly, that's exactly what defense counsel asked for the court to do. State acquiesced. So that shouldn't even be an issue before the court.
I'm sorry, the defense asked for the alternative counts?
Right.
That's part of your invited error.
Correct. At sentencing, the defense, on each of those 5 counts that he was convicted of, asked for the lesser count to merge into the upper count and to have that lesser count dismissed. Were there any further questions on that particular issue? With respect to the lesser includeds, from the state's perspective, I think that the Court of Appeals put a pretty good example in there as far as winners, where they set forth where someone had been convicted of both an Ag 4 battery and a Level 7 Ag battery. The jury in that particular case convicted them of both. That particular court found that there was no error in the courts merging the two counts at sentencing, even though there was not a lesser included instruction at the time of trial, because the court had given a instruction to the jury to consider each charge as a distinct and separate charge. So jury had the option, he can be guilty of aggravated 4, he can be guilty of aggravated battery Level 7, or he could be found not guilty. Essentially, that's what the court did here. They, on each one of the counts, they gave the option of the alternative count, so they can be found guilty of, say count 1 was aggravated crim sodomy, I believe the alternative of that was crim sodomy. But the court did what this court is instructed to do as winners, as it gave the jury the instruction to look at each count as a separate and distinct conviction. And at that point, because it did that, that saved that error. Was error on the part of the district court not to give the lesser included for count 1, but this court has said that that's a cure for that error if it gives that separate and distinct instruction, which is clearly done in this situation, and the state's perspective that we have cured the error that was committed by the district court at the time of during the trial on the lesser included issue. Is there any other questions on that issue? Okay. With respect to the inquiry into the conflict with trial counsel, this was an issue brought up at sentencing after the conclusion of trial. Like I said, at the time of sentencing, from the state's perspective, the court did make a proper inquiry into the conflict between counsel. Frankly, the state doesn't even see this as a conflict. in order, essentially the methods for having someone withdraw as counsel's conflict of interest, irreconcilable difference, or breakdown in communication. Although this is classified as a conflict, there was no clear conflict showing that the counsel was not adequately representing the client or even going in his best interest. During the time of trial, the defendant was given the opportunity to say whether or not he wanted to testify. He was having communication with his client. He, at that time, even, at least through sentencing, acknowledged that the letters were known to him. It wasn't until after the time of trial that he brought up the issue of wanting to have those records subpoenaed. His defense counsel has the opportunity to make the determination of how she wants to run her case, whether or not she wanted those letters included. That was a discussion between the two of them, but that doesn't raise a conflict of an interest. That's essentially a buyer's remorse situation. Had he had the issue with her representation and brought that up at trial, that'd be a different issue, but he brought it up after the fact. And the state believes that the court adequately and properly inquired into any conflict on that particular issue. And finally, with respect to the issue of nullification, from the state's perspective, the court did what they were supposed to do. They followed the PIC instructions, which says your verdict must be founded entirely upon evidence admitted and laws given in the instructions. Their defendant is not entitled to have a nullification instruction. That's not a right that's presented to them. But what isn't permitted is that we are to instruct the jurors. They're to look at the evidence that's brought before them in court. They're not to go outside of the court and do their independent research. They're not supposed to discuss the case outside of the confines of the jury room until after they've received all the evidence. They're not supposed to drive by the scene of the incident. They're not supposed to do anything other than hear the evidence that is presented to them, and that's what's told to them from the entirety of the case, from the initial instructions through voir dire, through arguments from the state and from defense counsel, and then again at closing. That's exactly what is to be done. That doesn't take away from their right to nullify. The word must, as has already been stated here this morning, does give them some wiggle room to still say, yeah, the evidence is there, this is not the way we want to go. But it's clear that the evidence that they are to consider if they are going to convict is evidence that must come to them from counsel in through the courtroom. And from the state's perspective, that's what that does. It doesn't eliminate their nullification abilities, but it does limit them, that they are not to go outside the scope of what is presented to them at trial by counsel in the courtroom. They're not to do their own independent research, but just look at the information that's provided to them. And the state does not see that as an error. And following the PIC is exactly what we are told to do, and that's what was done in this situation. And again, the state does not see error there.
Counsel, what's your position in regard to opposing counsel's suggestion that must should have been should?
I think you're getting to the point where that semantics, that's going to make sense to us as lawyers, but is that going to be lost on a layperson? And I think that's making a distinction without a difference between must and should. That, you know, I tell my child that she should do something. There's not much difference between that she must do something. I don't see that as a directive that's going to make a difference in the overall scope of things, especially given the number of guidance and warnings that are given to the jurors throughout the course of the time of the trial. Each break that they're told what they cannot do, which is go outside of the courtroom. So I don't see how that simple verbiage change is going to at least make such an error to have a verdict set aside in this particular issue.
Are you saying should is the equivalent of must?
I'm saying I think that's making a distinction without a difference. So no, they don't.
But your argument basically is that must is correct, because we've already told the jurors you must not read the newspaper, you must not look at anything outside, you must not do anything to gather evidence outside of what's admitted. And so when you say you must at the end, consider only the evidence, that's just a continuation of what they've been told the whole trial. Every time they recess, they're told you must not consider any evidence, right?
True.
In that argument, the way I hear your argument is doesn't matter if must and should or can. You're saying must is correct.
I think putting should in there, I don't know that would it solve the issue? Possibly. I don't think that's enough of an issue. That may be something that's worth taking a look. But if we're not adding a separate jury nullification instruction, which would not really be appropriate, I just don't see how that's going to change the overall outcome of the case and still make it more clear to the jury that whether they want to nullify or not, they are able to do so without that specific and explicit instruction given from the court, which has been the findings of this court throughout longstanding precedent. So I'm not sure if that's answering your question, but I don't know that either should or must. I don't know that either one is going to make it more clear, and that nullification is either something that they're able to do or take away from their already inherent knowledge that nullification is an option for them to consider as it goes through their verdict consideration process.
Do you have any further presentation?
Thank you.
Have any more questions of counsel before she steps down? Thank you, counsel.
Okay, please, court counsel. I want to clarify. I think counsel said it correctly, and I just want to make sure the court understands that what on the first issue, as far as what defense counsel requested, as far as the alternative charges, was at sentencing, once he had been convicted of both, that the ag incest go away and he'd be sentenced on. He'd be sentenced for for both 2 crimes for 1 act. That's what he requested. There wasn't a request, as far as I remember, earlier in the case, where these instructions go or anything prior to sentencing, that those should be included or charged. And she said that correctly. I just want to make sure that the court.
But he requested the higher.
Sentencing on the higher.
Yeah, he requested sentencing on. I think yes, he requested sentencing on the higher. I think it was a multiplicity argument. His argument was it's multiplicitous, and yeah, I believe that's correct.
So they should merge.
They merge. He gets sentenced on that.
Quick follow-up, if we disagree with the Court of Appeals sua sponte reversal of, I think it was counts 3 and 11, am I correct that what I described as a hiccup earlier, the fact that the jury found the defendant guilty of contradictory charges, am I right that was not, we can't reach that, whether that's a problem or not, because that was never appealed. There's no issue that presents that question to us.
I think that's right.
Okay.
And just I looked at the instructions, and I think maybe the instructions were wrong, but the instructions the ag incest instructions said that he intentionally engaged in sexual intercourse, that CDT was 16 or 17, that knew that he was related. I mean, the difference between the two is consent, but that's not in the jury instruction. The jury, you have in the other one, so it was an additional finding on the ag crime sodomy and the rape of a lack of consent. But I don't know that they were necessarily contradictory.
So the instruction on the incest charge left out an element.
Well,
because it has to be otherwise lawful.
Right.
And that element was not, that's what you just told me.
That's right,
that
yes,
element
that's
is
right.
not included in the instruction.
That's right, I do not see
that. Could actually explain why the jury did what it did.
That was my point in raising that. That's correct.
Thank you.
Yeah. Counsel, in talking about the nullification, I guess, it talked about that this is a PIC instruction. And it's always surprising to me when courts use the PIC as a rationale that this is a legally appropriate instruction. It seems to me the PIC committee and PIC should follow this court, to a lesser extent the Court of Appeals, and that maybe notes on use, how it should be used, this or that. But whether it's a legally appropriate instruction, I don't think the PIC committee doesn't get to decide that. I think this court and the Court of Appeals decide that. So I don't think the fact that this is PIC leads any credence to the fact that it's legally appropriate.
What about the point she makes that from the beginning, the jury is instructed not to consider anything outside the courtroom? In fact, we have a instruction that mistrial is a huge expense to everyone. At the very beginning, every time they recess, the jury says you're admonished not to read the newspapers, not to listen to the radio or watch television, not to consider, don't go to the scene. They're told all of that. You cannot consider or seek or look for evidence outside the courtroom. It's got to be all in the courtroom. And then you get to the final instruction, they're going, oh, well, you can or can't decide on whatever you want to do. How is that not confusing, if nothing else?
Well, then maybe you asked earlier about what a kind of instruction do, because I think we are in favor of the instructions that they must consider the evidence that occurs in the instruction. I don't think it's part of the inherent nullification to consider evidence that is not presented in that. So that's it. So maybe the instruction needs to be more clear that you base your decision on the evidence as is presented, but that and should find that the law. And there's a difference between the evidence and the law, I think, and when their ultimate decision. Sorry.
No, go ahead.
Well, the nullification directly is talking about their decision to convict, and unless the evidence, not the evidence that they're relying on, but the fact that we found him guilty based upon evidence and the law, but we don't want to convict him of that because of our own sense of justice.
What we really have is that a defendant can appeal on the insufficiency of the evidence to support the conviction, but the state has no right to appeal that the evidence was overly sufficient.
Right.
To and that the jury should have convicted based on the evidence. And so isn't that really where we are? Is the sufficiency of the evidence is a one-way street?
We've chosen that. That's not a incidental, unfortunate part of our jury system. That's one of the main reasons we have a citizen jury system. Maybe not the best way to find things is to pull people off the street, but we want that because we want that check on the state.
I just pulled up the PIC instruction for newly impaneled jurors, the introductory instructions, and just as a test to make sure I'm understanding your argument. It sounds as if this instruction does at least a part of what you want in terms of separating the law from the evidence, but it still uses the word must, which I think you would disagree. But it says, at the end of the case, I will instruct you on the law that you must apply to the evidence in order to reach a verdict. For your verdict to be fair, you must not be exposed to any information about the case, the law, or any of the issues involved in this trial beyond that which is admitted during the trial. So as I understand it, you would be okay with that second sentence. You would just want the first sentence to be changed from must to should.
You must apply the law.
Apply the law.
That would be. I think that would be consistent. Yes.
This is my problem. It seems like even with nullification, the jury does its job as instructed initially. They apply the law they've been given to the facts that have been shown. And then they just decide that in spite of that, they're going to acquit. They exercise mercy or some super extra legal, I think is the phrase my colleague used, judgment about the case. But in the initial stage, they still must apply the law to the facts that have been shown in the courtroom. You don't disagree with that, do you? They do that. Then they just make another judgment, an additional judgment that we've endowed the jury with the power to make.
Right, and again, let
But
me
we've
go,
said we don't tell them they have that power explicitly. We have, you know, those cases are out
Yeah,
there. You're not
sure.
arguing to overrule them. They are what
yeah,
they
yeah.
are. Isn't that really what's happening in nullification? And as my other colleague described, you know, we have it set up to have this one-way street, but we've said we don't tell the jury explicitly that that's how it works.
right, but we also,
If you give them discretion not to follow the law, then
But-
what is a trial?
well, no, I think it is, if we give them discretion not to convict, then we're empowering them to impose their own sense of justice. And I think that is why we have juries. And it is a discretion. And the idea, I mean, this happens with prosecutors all the time, right? Prosecutors, the person, they can have a set of facts and see that this is the most serious charge, this is what the person did. But in this situation, we're not going to seek a conviction on that, or we're going to plead to this. And we don't call that prosecutorial nullification. We don't, you know, it's discretion. And the jurors have that same discretion. And unless we take it away from them. And the idea that the jurors, well, they're lawless jurors, they're just going to do what they want to do. If they're going to nullify, it doesn't matter what we tell them because they're disregarding the law. I don't believe that. I believe that jurors want to do the right thing. We see questions from jurors all the time where they're seeking information because they want to do the right thing. And if we tell them their verdict must be founded on the elements, then the jurors are going to do that, even if their own sense of justice would say not. I mean, isn't that what we want? If we have a juror that says, "Boy, this isn't just. This is not just," what should that juror do? Should they sign the line? Sign the guilty line? This isn't right. But that's what it is. Okay, yeah, I'm out of time.
Well, just a quick thought. When a jury finds a not guilty verdict, the court, no one really ever knows why, I guess, unless it's inquired to post-trial.
Yeah.
Isn't that right?
Sure, yeah.
So how do we know when a jury's that the state's proven its case and we're just going to dispense with what we think is proper versus, well, you didn't reach reasonable doubt on this one element or something like that? What's the difference?
Well, I mean, there's, I think, how do we know?
Why do we need to know?
Well, I don't know that we need to know. I mean, I'm not suggesting that we ask. I'm suggesting that we don't tell them that they can't do it. And I believe there are studies that have looked at states that affirmatively instruct jurors on nullification. And there are higher degree of acquittals in those states. And again, we know why? No, maybe the prosecutors aren't doing their job well. We don't know. But nonetheless, and it goes back to, we can argue about this, that, and the other, but this instruction is legally inappropriate. And in some extent, your questions about, well, this hurts defendants, it feels like, well, you shouldn't be raising this, counselor. Which, you know, there are people that would agree with you on that, but I am. And I don't know the fact that this may hurt defendants' instruction. If it's legally inappropriate, then it shouldn't be given.
What if the instruction said your verdict of conviction must be founded entirely upon the evidence and the law is given in these instructions? Does that satisfy you?
I don't think so. I'm not sure. I'm not sure what you changed there. I apologize. Your verdict of conviction, because they're convicting. If we're saying that their conviction must be founded on the evidence and the law, that sounds very similar to the instruction that was given in this case. That we're telling them if it has to be found on that, then it can't be founded on their individual sense of justice. So I would have a problem with that.
It is telling them, isn't it, that it can acquit. And the acquittal does not have to be founded entirely upon the evidence and the law. It can be what you're suggesting, nullification.
Because the language you used said the conviction must.
A conviction.
I'll be honest with you. When you read that to me, I did not understand that. And there are certainly jurors out there that are smarter than I am, but I've been reading about nullification for about a week now, and that didn't register with me. I'm not sure that a jury is going to pick up on that nuance. If you throw in a language that your acquittal does not have to be based on the law, throw that in, then yeah, I'll take that. But that you didn't put that in there.
I did not.
Yeah.
we have any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement